Senator Surovell, you have SJ number 4 on page 22 of your sheet. We're also in the same group going to take up SJ 15, SJ 16, SJ 41, and SJ 73. So, but we're going to let you go first, Senator Surovell.
Thank you.
Senator Surovell, I think you brought this bill last year, if I recall correctly, before this committee, and based on the research that we've done, there's an archivist of a federal archivist of the United States, David Fierro, if I'm pronouncing his name correctly, appointed by President Obama, and he has opined that this amendment is not properly before the states. It's not one of the 4 amendments that Virginia or any other state can consider at this time. He has classified it as a failed amendment. So as you know, this committee has had a long-standing policy, at least since I've been around, that we do not memorialize Congress, and that's why we're going to take up a number of other bills going forward. So whether the idea is valid or not valid, supported or not supported, is not the issue for the committee. We just don't tell Congress what to do in that particular direction, thus memorializing them so that we can focus on the business that we can actually take care of here in Virginia. I do think that it is properly before members of the Congress, Senator Kane, Senator Warner, and I guess for you it would be Congressman Connolly, is that correct? Beyer. Congressman Beyer would be the appropriate individuals to look at this. So I am happy for you to present us anything, and I don't know that the case law has changed, and certainly we looked into it, letters dating back to I believe it was 94 from Attorney General saying that this was not properly before the legislature in Virginia. So do you have anything to the contrary?
Sure. So a couple things. Number one is the state of Nevada ratified the Equal Rights Amendment last year.
Do we live in Nevada?
No, not
Okay.
that I checked, but
so do you have anything different?
I have an Attorney General's opinion from 2015, which I didn't bring with me, or Attorney General Herring opined that he thinks it's viable. It's probably about a 12-page opinion. I'm happy to provide it to you later. I don't have it with me right now, but I believe what he said was that there's a long-standing history in the country of, first of all, the Constitution doesn't require any ratification deadline to be in any amendment, and most amendments didn't contain that until probably about 1920 or so. And so the idea that an amendment has to have it, or the Constitution requires it, or that somehow necessitates it, isn't really valid, number one. Number two, Congress can always adopt an act retroactively, recognizing ratifications that occurred after the ratification deadline. So some people believe that can happen. Also, this state has ratified many amendments well after the ratification deadline. For example, I think it was the 20th Amendment that gave women the right to vote wasn't ratified by this state until about 40 years after it was adopted. I think we were the 48th or 49th state to ratify it well after the other states had ratified it. So I think the ratification issue is one that is sort of in flux. And again, I have an Attorney General's opinion which says that simply because it hasn't happened yet doesn't matter.
Senator Saslaw.
Seems to me, I could be wrong, I don't think I am, a few years ago, Congress, finally the states ratified one that had been out there apparently for more than a century,
right,
dealing with congressional compensation.
Right.
I mean, it had been out in the
We're going to go through the chair, and certainly Senator Saslaw has the ability to speak. Senator Saslaw, the research that we did, I think that Senator Surovell is correct that they do not have to have time frames, but if some of them do have time frames, we are not in control of what the federal government does, the Congress making determinations. When we did check with the archivists of the United States, they indicated that there are 4 amendments that are properly before us. They also indicated that some amendments, as you accurately said, do have time frames and do not. We don't have any control or determination over that. They indicated to us that the Congressional Apportion Amendment, the Titles of Nobility Amendment, the Corwin Amendment, and the Child Labor Amendment are the 4 amendments that are still properly before the Commonwealth and other states. So that's where it is. So I'm certainly sympathetic to the issue coming forward, but if it's not properly before, we're not going to memorialize Congress, and it's not a question of on the issue, but we're going to have 5 or 6 other pieces of legislation that attempt to also memorial Congress that we're going to take up here shortly.
Got it.
Senator Hanger.
Thank you, Mr. Chairman. Recognizing that it's not properly before us, I would like to recognize some efforts that went on this year. Specifically, I received probably in the range of about 250 postcards that had this cute young lady on the front of it there, and I'd like for her to stand. I've got a whole collection of cards from her. And while it's not properly before us, I really do appreciate your effort in fighting for a cause you believe in. Thank you.
Senator Surovell.
I would just say two more things, Mr. Chairman. Number one is I don't think the U.S. Archivist or the Library of Congress or whatever decides what the law is or isn't. I think the U.S. Supreme Court decides that. So, but beyond that, the other thing I just want to say is I think if we could ask anybody who's here who supports this to stand
Absolutely.
up.
Well, all the individuals are here to support. Please stand up. Thank y'all for being here and to express your support for this issue. Thank you. Well, if there's anybody here that is not in favor of the amendment, would you please stand as well? People who were support, please sit down. Is there anybody here not in favor of the amendment? Please stand. Thank you for being here. All right. Senator Marsden, I assume you're not standing up in this group. I raised my hand. Yes. All right. Senator Surovell, we're going to take up the other bills in this block, and then I'll come back to you for the remaining of those.
Thank you, Mr. Chairman. I'd like to take SJ4 out of the block.
Okay. The motion that we'll vote on initially is SJ15, SJ16, SJ41, and SJ73 be PBI'd because of the nature of memorializing Congress or a foreign government. All in favor of that, please signify by saying aye. Opposed, like sign. That motion is agreed to. SJ4, the motion is to recommend PBIing because of the nature of memorializing Congress. All in favor of that motion, please signify by saying aye. All opposed, like sign.
No.
So the motion is agreed to. There's no. For the members of the audience who are requesting, as you've heard through all these, if there are a bill, which is a SB, then they are recorded. If there are SJs, then by the rules longstanding of the Senate, those are not recorded votes. So moving to the next group of bills.
This is not right. It's not right. This is wrong.
The next bill, Senator Hanger, SB 234.
This is wrong. We're not audience members. We pay your bill. We are your
Late. Senator Hanger, if you could please present your bill, SB 234.
Thank you, Mr. Chairman.
This is ridiculous.
SB 234 concerns the Advisory Council on Autism. Mr. Chairman, this would be a routine extension of this currently existing council. The only question I have is Senator Stewart has a bill to do a very similar thing, and I wanted to ask
Mr. Chairman, I think it'd be easier if we had a recorded vote.
Mr. Chairman, I serve as chairman of the current existing council, which we want to continue. I would ask that, Mr. Chairman, I would ask that Senator Stewart's bill, Senate Bill 337, be rolled into Senate Bill 234, and Senator Stewart be listed as the chief co-patron. And with the understanding, we're going to work out some of the details to include the membership that he wants to include.
I second that, Mr. Chairman.
Thank you, Senator Hanger. The motion is that SB 337 be rolled into SB 234. All in favor of that motion, please signify by saying aye.
Aye.
Opposed, like sign. Senator Hanger,
Mr. Chairman, I would then move that those combined bills be reported.
so we do have some other business that we have to proceed. We're so, we are the huh? Yeah, we'll show that.
Yeah, let's do it. Want me to- You'll request that.
We're not simply pressing that for a vote. We want to show that we do have to.
Why don't you show that, have a show of hands?
I will if you let us get to the. If members of the audience, if y'all would allow us to be able to continue forward with the committee meeting, then we would be able to take up the issues that are important to you, not just that one. But if we are not able to actually proceed forward with members being able to talk, then we will have to have the room cleared. But we don't want.
Mr. Chairman. Mr. Chairman.
Mr. Chairman, Mr. Chairman.
Ma'am, if you can, if the audience will be quiet so you could speak. So, ma'am, if you could hold on for one second. We do have a motion on another bill that's before us. As soon as we're done with that, we will come back to this one, and I will allow you to speak. Okay, thank you. That's what we were trying to articulate. So, Senator Hanger, you
Thank you, Mr. Chairman. I would move that the substitute that we're creating with rolling Senate Bill 337 into Senate Bill 234 be reported.
So the motion is that 337 we've already rolled that into 234. The motion is that be recorded. Because this is a bill, the clerk will open the roll. All members voted. Any member, he's not here. Any member required to change their vote? The clerk will close the roll.
Ayes 14, no 0.
Ayes 14, no 0. That is approved. So going back, ma'am, I can't see you. I'm sorry. Come on up. Tell us who you are.
I've long been a member of the League of Women Voters, and now I'm on the Women's Rights Task Force of the League of Women Voters. But I've been working on this issue for about 40 years. Senator McDougal and all the members, the honorable members of the committee, we have heard today some comments about why the committee should not memorialize the Constitution to the United States Congress. We are not asking you to memorialize this bill. We are asking you to pass this bill, as other senators have done in Virginia over the many years in the past. You may notice that the state of Nevada has recently passed the Equal Rights Amendment, and in order for the amendment to pass this so that it becomes a part of the Constitution, we only need 2 more states for a total of 38 to make this amendment a part of the United States Constitution, and thereby to include all citizens, regardless of gender, the full protections of the Constitution. When you mentioned that the archivist had ruled that the deadline is standing, we need to point out that the archivist only gave one opinion. That opinion is not a legal binding opinion. It did not come from Congress. We know now from other legal opinions that the deadline was attached to the amendment illegally with the express purpose of defeating it. But we now show that if enough states ratify the Equal Rights Amendment, which is only a purely justifiable amendment, giving all of us equality of rights under the Constitution, whether we're a woman walking into the court, a girl, a man, a boy, we would all get equal treatment. Right now, we do not get that equal treatment. Therefore, we need to tell you that the deadline does not preclude the Senate of Virginia from ratifying the amendment such that it can be passed along if we can get the House to ratify, which is unlikely because they are devotedly against the cause of women and equality in the United States. So we ask you to join the other states that have ratified and allow Virginia to move forward in terms of justice for all Virginians and all citizens. We ask you this today because we're hopeful, we're not begging, but we're so hopeful that you will look into your consciences and do the right thing.
Bravo! Bravo! Bravo!
Mr. Chairman,
Senator Howell,
I'd like to move that Senate Joint
well,
Resolution 4 be reported.
before we get to that, because we have taken comments for, I think we need to give the opportunity for comments against. And then we are not going to change the procedures of the Senate with a recorded vote on SJs because we do not do that. But we are going to have a show of hands on this particular bill to make sure that the members of the audience and those, because we do stream these, others can see that show of hands.
Mr. Chairman.
Mr. Chairman,
Senator,
I'm an attorney.
Hold on. We're going to, if we cannot do this in an orderly direction, if we cannot have one person talk at a time, then we're going to have to empty the room. That's not what we want to do. That is not a good decision, but we have to be able to talk through this, and we are going to have a show of hands at the end on Senator Howell's motion. Does everybody understand? Okay. Senator Howell.
So, I'm sorry, we will have a show of hands?
Yes, yes,
Okay.
Senator, we
Now,
will.
Mr. Chairman,
Yes, ma'am.
parliamentary
Yes,
inquiry.
Senator Howell.
I believe that if 20% of the members ask for a recorded vote on a joint resolution, that we can get one, but that's a parliamentary inquiry.
It is, Senator Howell, on amendments to bills, you are correct that if there's a voice vote, that there's 20%. But on resolutions, we don't record votes on resolutions. As the senator is well aware, we take up hundreds of these throughout the year, and we don't record those votes. But because Senator Howell, you have requested, we are going to have, and you and Senator Saslaw both requested, we are going to have a show of hands of the members. So, Senator Saslaw.
Seems to me that in the past, when we've had an SJR concerning constitutional amendments, and essentially this one, because we haven't had a lot before us, it seems to me that because it was a constitutional amendment, that we did have a recorded vote in committee.
Senator Saslaw, we're going to have a show of hands because you and Senator Howell requested that. Right. And Senator, that's what we're going to do. Right. So everybody will be able to see. But ma'am, Because there are other people that want to talk, we're going to put 3 minutes. I'm not going to count the prior speaker against that. You have 3 minutes, but it is a hard stop. At 3 minutes, we will stop the comments, and then those against will have 3 minutes to record, to respond, and then we will have a vote. So,
Okay.
hold on.
Yes,
I don't
sir.
want you to, can you reset the clock, Hobie? So, yes, all those in favor, please line up for your 3 minutes. Yes, ma'am. Tell us who you are.
My name is Julia Tanner. Mr. Chairman and honorable senators, thank you so much for your time, but I will be quick because there are others behind me. My name is Julia Tanner, and I have 2 daughters. We are residents of Virginia, and I am here to explain to you that this legislation is not a nullity. I also have 2 letters to the editor from citizens in your district, which I would be happy to submit for the record, as well as a resolution from the county of Fairfax, which is by population the largest county in the state, asking you to please ratify the ERA with SJ4.
Thank you very much for being here.
Thank you, sir.
And you can submit those letters and we'll pass them out.
I will do that. Thank you so much. So regarding the archivist letter and the argument that we've heard, and I am an attorney, and it is simply an argument, it is not actually a, it is not a proven fact, as the Attorney General's office has said. At the moment, there is no certainty on this fact at best case, and at worst case, for those who do not agree with this amendment, we are correct. As Professor Wendy Murphy, who's an expert in women and the law at the New England School of Law, has said, the Supreme Court never actually ruled on this issue. And I actually read this case, and I've read it several times. It's based on a 1-page memorandum, and it is like a 2-sentence dismissal based on a 1-page memorandum. You could go read it right now. National Organization of Women versus Idaho. The Supreme Court never said this is a nullity. They never said states cannot ratify. They never said Congress cannot move the deadline. And in fact, in various cases, Congress has moved a deadline. States have ratified after deadlines. Professor Murphy emphasizes, therefore, it is not the legislature's role to determine unsettled constitutional questions. It is the legislature's job to pass laws and let the courts deal with the constitutional issues. And the case law bears that out. I would love to meet with you afterwards if this does not pass, but I urge you to reconsider your positions. Please, for the women of this Commonwealth, for women sitting on this committee, for women, the 96% of Americans who favor passing the ERA, and for all of the many constituents who do believe that this is what you all should do, we do ask you to please ratify the ERA. Thank you very much.
Thank you. Yes, sir.
Thank you for this opportunity to speak. One of the questions in this debate is, does the Constitution already cover sex discrimination? And the question, as answered by Supreme Court Justice Scalia, the question is not whether the Constitution requires discrimination based on sex, but rather if it prohibits it. And it doesn't. So in essence, what he says, if you want equity under the Constitution, go out and get an amendment. And that's what these men, and that's what these women, and that's what these children are here for today. I find it very hard to understand why you don't want your name on historical legislation. This will put Virginia on the forefront of equal rights, which will result in a better economy, companies coming to Virginia. I tell you what, these men, these women, these children, if it's not passed this year, if it's not furthered for debate, they'll be back next year. And if it's not done next year, they'll be back the year after. And they'll be looking at different faces on this panel, people that will pass it. I have to tell you, I have 3 daughters,
You've
6
used up
granddaughters.
all the time for the people behind you. So those who are standing up, if you would please come forward and tell us your name, and I assume you're supportive of the position.
I'm very supportive of the position.
Thank
on
you.
behalf of my 3 daughters, 6 granddaughters. I'm here to tell you they're not the weaker sex, but they should be the equal sex.
Thank you, sir.
Thank you.
please tell us your name?
My name
and
is
that you-
Eileen Davis, and I just want to speak briefly about the
Ma'am.
abortion issue. I send you all a letter, and I know that that's the
Ma'am,
elephant in the room.
we've-
I understand, Mr.
we-
McDougall,
ma'am,
please. I've
we're-
tried to meet with you since January, and I was told that I would have...
Ma'am, ma'am,
And I would have public opportunity to speak with you in committee, so I am going to take that, and I will be brief. Just allow me.
turn it back on.
What I would like to say to you is that the elephant in the room is that, and I know the opposition is saying that this is a secret abortion bill. As a nurse who has worked in a church-sponsored clinic, I take extreme offense to that statement because it absolutely is not true. Excuse me? I'm going to quote. Roe v. Wade was decided on the constitutional right to privacy, and there is nothing in the statement, equality of rights under the law should not be denied or abridged by the United States or any other state on account of sex. It speaks to pregnancy, uteruses, etc. The legislative history concludes that abortion is not a sex equality issue. Thomas Emerson of Yale Law Review concluded that abortion is a unique issue for women and hence does not raise any questions of equal protection and is not a sex equality issue. In lawyer speak, this is the obvious. Men cannot get pregnant. Now, as a nurse who worked as a birth educator nurse with decades of experience, I want to tell you a ratified equal rights amendment would actually reduce abortions. Why? Because as a health professional, I can tell you each and every time, in the many, many times I've ever told a woman she was pregnant, if this wasn't received as happy news, the first words uttered is always some variation of, I don't know how I'm going to afford this, I can't afford another child, I cannot lose my job. Over decades, this narrative has never wavered. I can't stress enough the correlation I have seen between a woman's economic and job security and her decision whether to continue an unplanned pregnancy. If you really want to support women and their unplanned pregnancies, if you really want to reduce abortions, empower women with a solid foundation of constitutionally guaranteed gender equality law, which would add strict scrutiny to our Constitution and strict scrutiny to economic equality, equal pay, and opportunity, and provide economic job security to women pregnant or not. Thank you.
Thank you. Ma'am, if you would please tell us your name and your support of the issue, the allocated time has expired.
I understand. My name is Katie Hornung, and as a fourth-generation Republican, I support Republicans taking leadership on this important issue and moving it forward to the floor.
Thank you, ma'am. Thank you, ma'am.
Hello, I'm Shamali Houth. I'm from Reston, Virginia, and I'm a 10-year veteran of the Air Force, serving both enlisted and officer. My husband's retired military. Virginia is home to a lot of veterans. We support the ratification of the ERA. It's very important.
Ma'am, just please tell us your name and your position. We've passed the time for advocacy. So
15% of the U.S. military and 20% of U.S. Air Force are women. We serve and protect the Constitution and defend the United States, but we are not protected by that same Constitution.
Valerie Philgrove from the League of Women Voters of Virginia. We do support the Equal Rights Amendment. I will just say one little thing. My grandson, who's 11 years old, puts it in a very concise way. He says, women do not have a contract with the Constitution.
thank you. Because we've gone over the time frame, everybody who stood up now, so we're going to have individuals who are opposed to the amendment give the opportunity to speak now. So thank you for coming. We really do appreciate that. And we know that you're in favor of the resolution passing, correct?
Correct.
Thank you very much for being here.
So are the 20 senators who have already signed on as patrons.
Yes, thank you. And we're going to have a raise of hands. So those individuals who are not in favor of the amendment, if you will please come forward to speak, if anybody so chooses to come forward.
I think it's important to know that the General Federation of Women Clubs has had a resolution supporting the Equal Rights Amendment for decades. As my name is Frida Cathcart, as a mother of 4 sons who is their soccer coach, I ask you to please pass the ball, please pass this bill. Thank you.
My name's Wendy Martin. I live in Richmond, Virginia. I'm a business owner. This is ridiculous what's happening, and it's going to be on the national news. We deserve a vote, and we've had it. Seriously, please.
Thank you for being here. Anyone who wishes to speak against the amendment, please come forward. Okay, with that, Senator Howe has moved. We are just, so she had moved and it was seconded that there be a vote. So the vote is on passage of SJR 4. So all in favor of that, please signify by raising your hand. 5. So all 5. All in favor, all in favor of not passing the bill, please raise your hand. The motion fails. The motion fails.
Mr. Chairman.
Thank you. Senator Carrico.
Mr. Chairman, we operate these meetings on decorum, and I chair a committee, and this is not the way we operate. I hope that everyone in here would have the respect of what the meetings are for. We've let you have to say your piece, and I think it's time that we move on.
We're just getting started. This is obstruction.
Thank you, Senator Carrico. Senator Lott. Senator.
Thank you, Mr. Chairman. Okay. Mr. Chairman, SJ 19